morning, Council. Now we're here for our second case this morning, Kincer versus the State of Washington. Appellant, Mr. Kertchen, you may begin when you're ready.
Your Honor, may it please the Court, my name is Vitaliy Kertchen. I am representing the appellant, Mr. Kincer, in this matter. The Court should reverse the Jefferson County Superior Court because Mr. Kincer is entitled to a restoration of his Washington State firearm rights. Mr. Kincer filed a petition with the Jefferson County Superior Court for a restoration of his rights under RCW 941040 subsection 4 and listed as his predicate a 1997 conviction for assault in the fourth degree with a domestic violence designation. The state objected on the basis of federal preemption. We went to a contested argument, and the judge, the commissioner, I think, denied the motion, the petition on the basis of federal preemption. There are three reasons why federal preemption does not apply in this context. The first is that the statute imparts no discretion on the restoration of state rights and does not require consideration of federal law. The second is that the state's argument is premature because we are not asking the court to direct the transfer of a firearm or the approval of a permit. And because the federal courts have already recognized that a state right and a federal right can coexist. They're not always in line with each other, but it's not like one can't exist without the other. So turning to the statute that governs a petition to restore firearm rights, that's 941040 subsection 4. Since 2003, there have been a lot of case law published on this particular topic from the Court of Appeals and from the Washington Supreme Court, starting with State v. Swanson. And I've cited those cases in my opening brief. I'm not going to mention them individually, but the point is that in the last 20 years, every single time that this court or any court has tackled the topic of restoration of firearm rights, it has reaffirmed one maxim, which is if the requirement isn't stated in the statute, then it's not a requirement. That has been a repeated theme of every holding of every court that has considered the issue. And the various prosecutors across the state have put forth a number of different arguments in order to curtail the broad grant of a restoration that's contained in that statute, and the courts have ruled in favor of the petitioner nearly every single time. And so that's what's happening here. The state is now coming up with some new novel argument that doesn't apply or have any relevance to the proceedings, and is asking the court to again curtail the statute and curtail rights. And so the court should not take that invitation and should reverse. The other reason is that if we look at the other statutes, particularly in Title IX, Chapter 41, regarding the transfer of firearms, the approval of concealed pistol licenses, and background checks in general, there are a number of statutes that require, in those contexts, the issuing agency or the agency doing the background check to consider federal law. RCW 941070 and 090 deal with applications for concealed pistol licenses and firearm transfers. And in those cases, it states if a person is prohibited of federal law, then they cannot either receive the permit or receive the firearm. If the legislature wanted federal law to be considered as part of the restoration of a state right process, it knows how to put that language into the statute, and it never has, not since the statute was initially enacted in 1985.
But the question isn't whether state law allows this. I think it seems like it's undisputed that under state law, your client is entitled to have his right to possess a firearm restored. The question is, obviously, whether federal law preempts that.
Right, and I understand that, but there's no reason why the federal law would preempt that, because we're not asking for the court to violate federal law. We didn't ask for the court to rule that federal law doesn't apply. We didn't ask the court to grant him federal immunity. We didn't ask the court to make any sort of determination about federal law at all. We filed paperwork in a state court pursuant to state law, asking for a state right. Federal was never even issued until the state lodged its objection. And
Although,
it's a premature argument.
Well, once you get the order from the court restoring the right to possess a firearm, that means it's legal under Washington law to possess a firearm, regardless of his prior conviction. Under federal law, it's illegal to possess a firearm. So why don't those two concepts conflict?
Well, I will allow your assumption in the question that it would be illegal for him to possess a firearm under federal law. That actually is not the case. But for the purposes of the question, the reason those don't conflict is because he's not actually in possession of a firearm. The order itself isn't in itself a firearm. I know that sounds stupid, but or obvious, but so he's not breaking federal law by having a state right restored and in his hand. That doesn't implicate federal law because he hasn't yet gone for the actual firearm. And again, not to sound obvious, but the order isn't a firearm, so that's why. And so if he were to go and attempt a firearm purchase and he were denied, and the Jefferson County Sheriff said you're denied because of federal law, and we filed a petition for a writ of mandamus, then the state could say, well, no, federal law prohibits us from giving him a firearm, and then they could cite Snohomish County v. Barr, or Barr v. Snohomish County Sheriff, I'm sorry, which is just directly on point with that procedural process or posture. So it's crucial to remember the posture that this case is in at this moment and not put the cart before the horse, which is what the prosecutor is trying to do here.
And
And
so
in my
that,
view,
that ability to later deny possession of a firearm under federal law when he goes to, or potentially goes to purchase a firearm and has the background check and all of that, is that also the reason why the state essentially permission with the court order isn't an obstacle to the accomplishment of the federal law because the application of the federal law isn't hindered by this order?
That's correct, Your Honor,
Okay.
because there is a separate statute that specifically states that federal law must be considered when doing a background check for a firearm transfer or for a concealed pistol license permit. And so federal law is relevant. It's just not relevant at this stage. And if the legislature wanted to make it relevant at this stage, then it knew how to do that. And we have My v. United States, which is a Ninth Circuit case from 2020, which deals with a similar issue wherein the petitioner, the petitioner there had received a Washington State restoration of firearm rights on the basis of a mental health involuntary commitment under RCW 9.41.047, but federal law didn't recognize that restoration. And he was denied by the ATF or the FBI and sued in federal court for determination under federal law. It was a Second Amendment challenge that federal law didn't apply to him, which he lost. But the point is that in that case, the Ninth Circuit recognized that a person can have their state rights restored. That doesn't necessarily mean that there's no federal layer to deal with at some point. It's just not at this stage. And so with that, given the procedural posture of the case where it's at currently, it's simply inappropriate for the state or for the court to take federal preemption into account. It's simply premature. So
Counsel,
with that, I'll cede the rest of my 50.
I do have one question.
Go
You
ahead.
mentioned transfer. And so I'm thinking of a situation where there might be an inheritance, right? So someone passes and they want to hand down their firearms to somebody. So you're not doing a purchase. So how would that, with that type of a situation, how would that be impacted, if at all? Or would that prevent your client from having a firearm?
I don't think that, so as you mentioned, there's no background check involved in such a transfer. And so at that stage, there wouldn't be a background check run. However, if a federal prohibition existed, then that person would still be prohibited by federal law and would be subject to prosecution if the feds were ever caught him or her. So I'm not sure. So I would rest on that.
Thank you.
Thank you, counsel. You may begin, respondent, when you're ready.
Thank you, Your Honor. There's no Washington appellate court that has decided how RCW 9.41.0404 and the Lautenberg Amendment should work together when a person is convicted of assault for DV and seeks restoration of firearms law under Washington, law. So what we're hoping for, the state is hoping for, Your Honor, is that the court would take this opportunity to provide guidance on that issue in a written, published opinion. I've had this issue now litigated in Superior Court a few times. This is the first appeal. And it's the state's position that under fundamental principles of federalism, the Lautenberg Amendment must be considered as part of the law that has to be satisfied before approving a restoration of firearms rights under Washington law. And there's no dispute that Congress adopted the Lautenberg Amendment with the stated purpose of creating a lifetime ban on possession of firearms for persons convicted of state misdemeanor crimes of domestic violence. And appellant has argued repeatedly that Washington courts can just simply ignore this Lautenberg Amendment. And that argument fails to account for U.S. Supreme Court and Washington Supreme Court cases requiring application of federal law when the requirements of a federal statute and a state statute cannot be met at the same time. And I think this is the point that Judge Maxa was making in his question to the appellant. Appellant has never addressed the preemption cases that we've cited since the trial court. And I point out, Your Honors, that there's a new argument being made here that there's a failure of proof on the part of the state. And that argument goes to the 1997 conviction for assault for DV. But there's also a second, or actually a first conviction for assault for DV in 1992. And appellant says, that's not even something you can get restoration for because the restoration statute only applies after 1993. And we've been focused on the 1992 conviction since the beginning. If you look at our initial objection to the motion to restore firearm rights, that it's in the it's at page 3 of the CP, and then our brief and further response, it's at page 16 of the CP. We talked about that. And one of the things I think we're missing here is that with respect to this argument, the appellant knows who his two victims of domestic violence were and what their relationship was to him, but he failed to provide any of that information to the court, even though there was a court order saying you should do that. And so if he had made that argument in the trial court, since this is a civil proceeding, then we could have done some things to address that. We could have served discovery on the appellant. We could have asked for the appellant to appear and show cause as to why the Lautenberg Amendment doesn't apply. But instead, they essentially admitted that the Lautenberg Amendment would apply to him. And so we think the fundamental principles here are related to federalism and preemption, and we think the trial court was correct in its decision and that the court should uphold that decision.
let's
that's my
say,
basic-
let's say
Sorry,
the
go
trial
ahead, Ron.
court, let's say the trial court had in fact issued an order restoring Mr. Kincer's firearm rights. Would it still be lawful for him to possess a firearm?
It would not.
Then what's the problem?
The problem is he would be exercising that state right in contravention to the Lautenberg Amendment.
Well, except he's not exercising any right. And I think, the argument is he's not asking that someone be required to give him a gun. He's basically saying, I want this piece of paper that says I have a right to. But federal law still predominates under the Supremacy Clause, and it's still unlawful for him to possess a firearm regardless of whether he has that piece of paper or not.
Well, what's the point of the restoration, then, Your Honor? That's the difficulty I have with that argument. I mean, this is a place where we catch these things. Is that the petition for restoration thing, situation? And if we don't catch them here, then he can make that application to somebody in the state of Washington, and they can issue it without respect to the federal law. The danger is that it's going to get past them, and that's the reason why we think preemption applies. He doesn't need a path to get to do something that's illegal under federal law.
But isn't that an argument that needs to be made to the legislature? Like, there are multiple other states who have expressly put in their restoration law that the person has to be able to possess a firearm under federal law. And so it seems like that's how those states are solving that practical problem. Why can't Washington do that? Why can't the Washington legislature or the people through the initiative process do that?
Well, I could say, Your Honor, that I wish the legislature had done that. It would have made life a lot easier for all of us. But they didn't do that, and it's not the first time they haven't done something like that when there's a conflict between state and federal law. That's, we wouldn't have the preemption argument. We wouldn't need the preemption argument if that were the case. We wouldn't be talking about preemption at all. It'd just be part of the state statute.
So I have a question that's a little bit in the weeds, but I noticed that in the federal statute, there's a prohibition against a person convicted of fourth-degree assault, domestic violence from possessing a firearm in or affecting commerce. And I'm wondering what that in or affecting commerce, how that applies. Does that mean that it has to be a firearm that's either come across state lines or is somehow implicating interstate commerce? Or does that mean something else?
Well, Your Honor, I will agree with you that it's a question in the weeds, so I'm trying to think of how to answer it. But I think the answer is that it doesn't take much for it to be in interstate commerce. That's my recollection of, the Interstate Commerce Clause and what's required for it. But that's about the best I can do on the fly, Your Honor.
My apologies.
No, not at all.
So I have another in the weeds question. It's okay if you can't answer it, but I've been trying to recollect what's the intersection in a Supremacy Clause challenge with the constitutional principles related to facial and as-applied challenges. And it sounds to me what you're saying is that as applied in these particular circumstances, there's a conflict. It doesn't sound to me like you're saying that the way that the state statute operates in Washington, absent a provision like exists in other states that requires compliance with federal law. Absent that, the statute is facially unconstitutional under the Supremacy Clause. It sounds like you're saying that every court should do an as-applied, instance-by-instance analysis of whether or not there's a conflict. Is that right?
I think that's right, and that's because the law has changed under state law as to when, when an assault for, or to whom an assault for DV conviction applies.
Okay.
There's a chart in our brief that talks about that related to the 1992 conviction, and there's not a perfect match between what the state law says and what the Lautenberg Amendment says in terms of who the victim has to be. The state has added victims to assault for DV convictions over the years that aren't covered by the Lautenberg Amendment. So I think that analysis is required under the current state of the state statute.
Thank you.
And Your Honor, I would add that I think this kind of comes into why the court asked for further information on the nature of the convictions, and none was provided. So, and instead, there was an assumption asserted by the now appellant that that federal law did bar his restoration through the Lautenberg Amendment.
Do we have any further questions? So it doesn't sound like we have any further questions.
I don't have anything further, Your Honor, unless you do have further questions.
Thank you, counsel. Mr.
Thank you, Your Honor.
Kertchen, if you can just wait a moment for us to reset the clock. Thank you. You may begin.
Thank you, Your Honor. The state mentioned towards the beginning of its argument that regarding the confusion about the 1992 case and 1997 case, I don't remember exactly what was stated in the state's briefing below. Obviously, in its response brief in this court, it did mention the 1992 case. The reason that we're focusing on the 1997 case is because RCW 941-0402A1 only prohibits possession of a firearm for an assault for conviction that occurred on or after July 1st, 1993. So there would be no reason for us to list the 1992 case on the petition or argue about it in any way, shape, or form. So we're just sticking with the 1997 case because it's the only thing relevant, because all we're asking is for the state restoration under state law, and state law doesn't prohibit possession for a pre-1993 case. And then the state mentioned something about we have to supply the relationship with the victim. We're not going to do their case for them. That's not our job. So I don't really understand where the state thinks that that's appropriate to place the burden on us, even though it's their objection. Then there was a question about the point to restoration. A number of individuals believe that whatever rights they can possibly get, regardless of whether or not they're preempted by other rights or other laws, are worth fighting for. It makes them feel whole. And quite frankly, the statute doesn't require us to have a reason to petition, which is again another reason why it's a mandatory requirement to restore so long as those statutory elements are met. So there is a solution to some of this that I can suggest that's employed in some other counties, which is just simply to issue a restoration order and then put at the bottom of it a warning that says, state law does not always match federal law. The end. And some of the counties across the state require those warnings, or at least they strongly favor those warnings on the orders that they issue. And I think a lot of what the concerns that have been discussed today can be simply remedied in that manner. And then finally, there was an allusion by by the state, something like, well, we wish that the legislature would have included, or a consideration of federal law, but it didn't. Well, according to principles of statutory construction, that's an important piece. The fact that the state didn't include that in the restoration part, but did include it in all sorts of other contexts, is a puzzle piece to this whole thing for the court. And it would be improper for the court to read that in, even though the legislature decided to keep it out. So with that, unless the court has any follow-up questions, I will submit the case, and thank you for your time.
Thank you, counsel, and thank you to both of you for your helpful arguments this morning. The remainder of our cases this morning will be decided without oral argument. So Division 2 is adjourned for today. Thank you.
All rise.